Hi everyone, Harry here to talk about two new important developments in the Alien Enemies Act case. It's been really fast moving and sort of chock full of court hearings and showdowns. Recall that there are sort of two things going on here. A continual tug of war between Boasberg and the government to get the information that Boasberg needs to determine if they violated his order issued in the emergency hearing Saturday the 13th. And they're going back and forth. The last move there was the state secrets privilege invocation by the DOJ. So now we're on the merits, not precisely the merits, of course, because all that Boasberg has done is enter a temporary restraining order saying, looks like there's some serious stuff here. And I will enter this order so we can figure it out. So this radical Marxist, crazy, terrible activist judge has done nothing more than see some meaty issues that everyone else sees. And the department hasn't even begun to answer for. And said, we want a TRO. All right, so in the last 24 hours, two big things happened. The first, I'd say the biggest. So the administration appealed the issuance of the TRO. You're usually not supposed to appeal an issuance of a TRO. The TRO pretty much gives the district court 14 days to figure things out. And the Court of Appeals will rarely disturb, but there's a narrow channel for disturbing if basically, it's a terrible situation, an emergency, and irreparable harm, etc., which is always the position of the administration. So they had an appeal to the D.C. Circuit saying, get rid of this TRO, something you don't do normally, but this is huge, and the president's authority to do what he will under the law. And who is this one district court judge to circumvent and totally disturb the president's huge need to do this for national security, never been done, et cetera, all over the top and false rhetoric. But it went to the Court of Appeals, and the panel looked pretty good for the administration. It had Judge Millett, who's a very strong, very good, very smart judge, actually pretty centrist, but a Clinton appointee. Judge Walker, who's a new Trump appointee, and Judge Henderson, a George H.W. Bush appointee, so a Republican, but a Republican who's been pretty hawkish on national security, pretty receptive to arguments of the sort that the administration has been making of, you can't second guess us. And at the oral argument, Judge Millett did 95% of the talking. Judge Walker did surface this pretty tenuous theory. And Henderson, who was obviously going to be the pivotal vote, said next to nothing. So it was really an encouraging event when this opinion came out yesterday, because Henderson went with the good guys and in a really forceful way. We actually have three opinions. She's the senior. She writes an opinion for the court that Millett joins. Millett has a separate concurring opinion. Walker has his own opinion. Walker propounds his kind of nutty theory that because everyone seemed to agree at oral argument, you can't stop people from having notice an opportunity to be heard to say, I'm not part of this Tren de Aragua group. You got the wrong guy. Everyone, even the United States, seemed to say that was okay. But a really cynical kind of suggestion, which Walker adopted, was you must do it in habeas corpus, and therefore, and people don't know who the people are. They were, when they were picked up and got no time to do anything, in God knows how many different jurisdictions the 150 or more people were. So it really was, uh, talking about, having to turn square corners and even worse, but that was his theory. Millett had a really strong opinion that also brought in constitutional values and had really, inspiring rhetoric about how when, the measure of a society's worth is how it treats the most controversial defendants and the like, things that, we've always taken for granted, but that Trump is proceeding to mow down. And then Henderson, she writes a strong and long opinion. It starts with all the history of the 1798 Alien Enemies Act and why, we're at war. It looks like we could be with France and they're coming in, and, why this is all inapposite, but basically makes clear that not only under the governing Supreme Court case, Ludecky, that you're going to be hearing a fair bit about, can the courts review this claim of does somebody have notice and opportunity to be heard to say, I'm not part of this group. They also can challenge the interpretation of the statute. That is Trump's determination that this is a predatory incursion by a foreign government. And she goes through what would war mean, what would predatory incursion mean. It really doesn't seem to hold up at all for what is essentially the presence in the U.S. of a couple hundred members of this group. And so it's I think, would be really an important development to be able to say, you don't get to just, tell us Humpty Dumpty style that a word means whatever you think it does, President Trump. We're going to decide, is this a predatory incursion and by a foreign government? They don't decide it yet, but they talk about the likelihood of success on the merits and go through it and why the government's argument is exceedingly weak. And they talk about the balance of equity and irreparable harm. And, the government has had the chutzpah to say, another day or 3 that people have to remain in this country is so terrible. What's on the other side? People being disappeared, possibly not members of the group or not valid applications of the statute, and just going away to a brutal torture center of just a notorious hellhole in El Salvador and never being seen again. That could happen because there's no more processing way to get at them. Henderson finishes by saying the balances are very much with the plaintiffs here, and no, we are not going to dissolve the TRO. Pretty great opinion, and she's a Republican, a sort of solid conservative on military matters, and it's kind of a great day when that judge comes out so strong for the basic claims of the plaintiffs, and it augurs really well. All right, just quickly then, Boasberg this morning was asked to dissolve his TRO himself. Why? Because of likelihood of success on the merits. Revisit this, please, says the administration. They're not likely to succeed. And Boasberg, really, in a 37-page opinion, totally mops up the floor with the government. And, in brief, I've mentioned these 2 different substantive claims. I'm not of the group, and this isn't a predatory incursion by a foreign government. And Boasberg marches through both. There are arcane legal reasons why that second set might be less likely to be subject to review. If it is, there's, the administration's position is really tenuous. But even if it isn't, the claim of individuals to have notice and opportunity to be heard before being shipped to the hellhole is still strong. And their likelihood of success on the merits of saying we have that right, not that they win, but we have the right to be heard, and it just can't be Tom Homan or Donald Trump who says, sorry, we've decided you're part of the group. That part is very strong. So on that basis, Boasberg denies the TRO. So the merits of the case, and in particular, the ability of the federal courts to determine these 2 really important issues. Are they members? And is the statutory interpretation, it's a construction and application by the administration accurate? It looks like there's a real head of steam, may come to the Supreme Court, but right now a real head of steam for saying that's for courts to do, not for the executive to arrogate to himself. Then we have separately brewing the whole, I want to know whether you violated the order. They've played the state secrets doctrine. I talked about that yesterday and why, Boasberg may genuinely be in a bind. We'll follow that. It'd be great if he could really push that to resolution here, but that the merits of the AA claim by the plaintiffs seem likely to succeed and therefore beat back a claim of excessive executive power, I think is a really, really encouraging day in this whole 2-month mess in which the Trump and company are trying to assume, grab, and not give up really extraordinary executive power. So that augurs well for that claim to be shot down, and that's a big claim, and it will have resonance to some of their other claims of excessively broad, unreviewable power. A good day.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.